I think let's get started. And for those people that join, that should be fine. Hello, I'm Kim Straker, and we're happy to be hosting our second HR forum virtually as part of a 3-session Return to Work series. I see that some of you here attended our first session, so welcome back, and a welcome to those of you joining us for the first time virtually. I'd like to introduce you to my colleagues, Sam Rubenstein and Ryan Schneider. Sam is going to kick it off today by discussing how to comply with New York Forward's reopening requirements. He'll talk about developing a business safety plan and the policies that are needed. He's worked with many clients recently in helping them plan for their reopening. He'll also discuss the New York State travel advisories and their applicability to international travel. Then Ryan will discuss domestic travel requirements, but Ryan's going to spend most of his time covering the federal and state COVID-19 leave requirements. We all know that the coordination of these various leave entitlements can be confusing, and Ryan will make sure that you leave here today with clarity and practical guidance. He's going to run through some hypos with you at the end. When we host these events in person, we encourage you to ask questions throughout the presentations. However, virtually, we feel that it works better if you hold your questions until the end of each subtopic. Ryan and Sam will both pause at different intervals and allow for questions. Or in the alternative, if you want to submit your questions in writing in the chat box, I will make sure that your questions get answered. And if for some reason time doesn't allow us today to answer all of your questions, then we will contact you individually after the event to answer your question. Hopefully, shortly before our event today, hopefully you received an email with a handout outlining today's discussion. We thought it would be helpful for you to have this during our discussion, but if for some reason you don't have that in front of you, you can always look right here on the screen. We're going to be sharing that outline on the screen so that you can follow along during today's discussion. One last note before we get started, we wanted to just ask you to mute yourselves just to minimize background noise. And also we wanted to let you know that we will be recording this event just so that we can send the recording out to those clients today, those clients who were unable to make it today. So with that, I'm going to turn it over to Sam, and thanks so much for being here today.
Thank you so much, Kim. I hope you're all doing well. I wish we could have done this in person, but you know, it's a crazy world, and I'm happy to walk through New York Forward today, as well as the international aspects of the New York State Travel Advisory. So to get started, you know, I think when New York Forward originally came out, it was sort of a region by region reopening, looking at specific industries being phased in. Nowadays, New York State, basically all of it's in phase 4. I think right now they're just trying to figure out how to reopen stuff like gyms that you probably read about yesterday, as well as indoor dining in New York City. But for the most part, New York City right now is in phase 4. The actual New York Forward, I'd like to separate into different documents. I mean, if you've ever been on the New York Forward website, I would highly recommend it. It's super helpful. It has a lot of information. But the first that's really helpful is called the short guidelines. So it's basically a form, depending on your industry, of course, basically shows what are the requirements and then what are the recommended best practices. I like using it as a shorthand guide to make sure that when we're advising clients on a certain policy that it at least meets the minimum requirement, and then sometimes it could have to meet the recommended best practices. The next form is something called the long guidance, which is sort of the meat of where you should be looking to making sure your policies are in compliance. And there within that document, if you scroll all the way on the bottom, there's a place where you're supposed to affirm. New York State is it's running on an honor system. So before you reopen, you need to affirm that your company is following this guidance. And it's as simple, I looked at the site before, you just click on it, brings you to like similar to what looks like a Google Sheet, and you just have to affirm that you're going to be following by the long-form guidance. There's also something called the Business Safety Plan template, which New York State provides, which is really nice as a sort of like, as you're thinking about reopening, like what are some issues to consider? What I really like about it, New York State, it's a template, so it's really easy to work through. You just have to check boxes. Maybe sometimes you could add in more information. And the biggest thing is you need to post that template conspicuously around the workplace. That's like a major thing that New York is requiring. If for some reason you're not sure which guidance your industry, falls under, maybe it's offices, maybe it's commercial building management, for example. There's also a really helpful lookup tool, which uses your business's NAICS code to figure out which guidance you're supposed to follow. I would just note a lot of the guidances, I would say they're 90% similar to each other. There may be some nuances, so definitely always make sure that you're following the right guidance. So as for the actual categories of compliance when you're developing your business reopening plans, I like to divide it up into 5 general categories. The first is physical distancing. Second is protective equipment and PPE. Then hygiene, cleaning, and disinfection, communication, and then screening. So physical distancing is basically how are you designing your workspace to basically, eliminate, limiting capacity. I think in New York State it's still 50%, at most 50% of your certificate of occupancy. So you always want to be limiting capacity. Making sure, especially in workplaces with open floor plans, making sure there's 6 feet of distance between workstations. Make sure people are wearing face coverings. The guidance says, in any common area, it may be a little bit different with a private office, but I always like to recommend if you're in the office, wear a face covering, even in the bathroom, because the way this disease is spread, just wearing a mask is really helpful. Some other stuff that we recommend to clients, having no more handshake rules, or try to limit your physical contact with people. Also staggering how your employees are maybe coming into the office. Maybe not everyone has to come in at 10 a.m. Maybe someone could come in at 11. So, or maybe you have to have an A-B schedule where someone just comes in Mondays and Thursdays, the other person comes in Tuesdays and Fridays. You want to be creative. As for protective equipment, I think the most important thing is that you are required to provide face coverings to your employees. They're more than welcome to bring a suitable covering of their own, but New York State is pretty clear that if you have employees and even on-site contractors coming into the office, you need to make PPE available. There's also, what I find unique about New York, there's like a training requirement when it comes to wearing these face masks. It seems a little bit silly, but New York State requires you to train for your employees to how to put them off, put them off, how to clean and disinfect them. It seems a little bit funny, how to teach your employees how to wear a mask when New York State requires it. The CDC has posted a lot of good videos, so there's no hurt in, telling your employees to affirm that they watch, these certain CDC videos, and then, you being as a point of contact to reach out if they have any questions. As I mentioned before, they have to wear their face coverings in common spaces, so that includes elevators, lobbies, kitchens, whenever they're just around about the office, highly recommend, and, that they should wear those face coverings. If you're in a workplace, where there's a lot of sharing of objects, definitely consider how you want to, limit that, because, what's the cleaning in between uses? If people are sharing the same computers, does it really have to be like that? How are you going to be disinfecting that? So also some things to consider, and any other frequently touched surfaces, from doorknobs to like printers. So just, you have to keep those things in mind. Hygiene, cleaning, and disinfection. I think a major issue is that you need to adhere to like the CDC requirements and the Department of Health requirements when it comes to cleaning. So it's stuff like making sure you have, water, soap, paper towels in the office. That at least 60% hand sanitizer is around the office, easy to use. Especially if, God forbid, one of your employees tests positive for COVID, do you have protocols in place to clean and disinfect the office? And finally, just, especially when I mentioned with open workplaces, like how are you going to make sure people who share a desk, what are your cleaning protocols? If someone comes in Monday and Thursday, is the person on Tuesday, you have to make sure that you're cleaning that desk before that person on Tuesday comes. Communication. New York State and New York City has posted a lot of signs and posters. You're required to post signage, inside and outside of the office. It's not really that difficult in my opinion. Just making sure at a place where employees can see, whether it be at the front desk or in the common area, you just want to make sure that you have all the signs up. Now, a big issue, which I'll go into the next slide, is what to deal with when you receive a report that someone tested positive or was exposed to someone who was positive. The big thing is that you need to, when you first learn of a positive case, you're required to contact the state and or local health department so that they are aware of it. So from a notification requirement, that's what you need to do. As for screening, New York State requires, at a minimum, 3 questions that you ask your employees every day. Some may want to go further. Some may even want to do temperature checks. So it depends on your preference. But at a minimum, you need to ask 3 questions, and they're posted on the guidance. 1, in the last 14 days, have you shown any COVID symptoms? Have you received a COVID positive test in the last 14 days? And or if you had any close or proximate contact with someone with a confirmed or suspected COVID case in the past 14 days. Because of the travel advisory that I'll talk about later, we have also started to encourage clients to ask questions like that. Has an employee in the past 14 days traveled to a state listed on the travel advisory or engaged in any sort of international travel? I'll explain a little bit more, but in a sense, the New York State travel restrictions is more of an individual requirement. We haven't seen any sort of, penalties for employers, but it's still a good question to ask. Just want to see, and it's an important thing to have a sort of a point of contact who will basically serve as the person, who knows everything about the site safety plan. For people, this person or persons, maybe you want to switch it up, will be in charge of reviewing the screening questionnaires that employees will be filling out, and as well as just making sure on a day-to-day basis that the safety plan is being implemented to its fullest. And then, so the next thing I want to talk about is returning to work. So, God forbid, you have an employee who tests positive or, just has symptoms. What are you supposed to do? So New York State guidance, this is from May, basically says if you have an employee who tests positive for COVID, regardless of whether they're asymptomatic or not, it needs to be 10 days of isolation after the first COVID 10 days after the first positive test if they're asymptomatic. But if they're symptomatic, then it has to be 10 days of isolation from the onset of symptoms. So you could see, so it's not just a straight 10 days. So if your employee starts to show symptoms, a week from now, that's when your 10 days start. But if you had an employee who had a close or proximate contact with someone with COVID, then and is experiencing symptoms, then needs to be the same thing, 10 days of isolation from the onset of symptoms. If someone had close or proximate contact with someone exposed to COVID, but is not experiencing any symptoms, then it's 14 days of self-quarantine. And so, as you can see, this kind of could start getting a little bit confusing. trying to figure out, should it be 10 days, should it be 14 days? I would recommend the New York State guidance is very helpful in figuring that out, as well as another confusing thing is that the CDC has its own recommendations, and from what I understand, that they were last updated a few weeks ago. And so another question I've been getting a lot is, hey, New York State is saying this, but the CDC is saying this, which one should I follow? So I've got through to someone at the New York State Department of Health, and their policy is that unless anything changes on their end, they're still following the state guidance. So if the CDC is more generous, of course, we would recommend you follow the CDC, try to be as, cautious as possible. But if for some reason, the CDC guidance is maybe not as strict as the New York guidance, definitely follow the New York guidance. Just on just New York forward generally, even though it's been out for 2 months, I'm still trying to grapple with it. The state makes updates maybe every few weeks to it. As the situation changes, there are other considerations to consider about. So definitely spend some time trying to understand the guidance documents. It's challenging, but you want to be in a situation where you are comfortable with your company's plan and that your employees are comfortable with their safety. And then just a last note that I forgot to include is complaints. So New York State has been encouraging, both employees to file complaints against their employers as well as individuals to file complaints against businesses. So we don't know what will amount to it, but we do know at least of one case. We had a client and an employee complained about the fact of how the employer was doing its temperature checks. So this is just as a sign to show that I personally think New York State is starting to investigate these issues, especially if they're complaints, and they will definitely be more aggressive, start sending letters. So just keep an eye on that. You're doing this not only just for your sake and for your employee's sake, but just to avoid any sort of possible litigation or investigations in the future. That's about it for New York Forward. I mean, 15 minutes or 10 minutes is not enough to cover all of it, but happy to answer any questions you have. If not, I'm just going to go briefly into the travel advisory, which is, an interesting thing that came up in June, where Governor Cuomo basically had this formula of determining which states would be, on this sort of travel advisory list. And the thing is, it changes on a day-to-day basis. So you always want to make sure where you're, what states are on that list. But from an international perspective, we had a situation with a client. Their employee was coming back from Canada for a work trip, and so they wanted to know what was the situation when it comes to, international travel, because if you read the travel advisory, it only applies to states, and so there was a sort of disconnect of what happens in international travel. So after I got through the Department of Health again and through the CDC and the Federal Department of State, generally how it's supposed to work is if your employee is traveling to a country that's on a level 3 COVID notice, which nowadays is basically every country in the world, in theory, when they arrive to JFK or LaGuardia, someone from the Department of Health will require them to, fill out that travel advisory form and for them to quarantine for 14 days. In practice, just what I've seen from friends who've traveled from internationally and domestically is that the Department of Health has been sort of slacking when it comes to this. So just keep that in mind. If you have any employees who are traveling internationally, I definitely recommend for them to quarantine for 14 days, even though it's an individual requirement and there's nothing in the executive order and the travel advisory that punishes employers. There may be a concern if you let an employee who's traveled internationally back into the workplace, another employee may complain about it to the state. So you always want to approach this guidance as a way to minimize the state try to investigate you. Before I turn it over to Ryan, I'm just going to ask if there are any questions, what I said so far, any clarifications. More than happy to answer them now or after the program. Okay. Well,
all right. Well,
none, I'm going to transfer over to you, Ryan.
Kim, did you want to step in and transition anything, or should I just?
You know what? I didn't see any questions come in. So don't be bashful, everyone, with questions. Feel free to jump in now with any questions, or you can write in the chat box. But I haven't seen any questions come in. So maybe we'll pause for about, 10, 15 seconds. And if nobody has questions, then Ryan, we'll move to you. Okay, Ryan, you can kick off your section.
All right. Well, thank you, Kim, and thank you, Sam. So I'm going to be continuing on Sam's discussion of the New York travel advisory, they're calling it. It's kind of more of a requirement, but on the domestic end for just a couple of moments. And then I'm going to talk about the COVID paid leave requirements under the Federal Families First Coronavirus Response Act and the New York COVID-19 Emergency Leave Law, as well as coordination with any company or business provided benefits to employees. So basically, as Sam was saying, towards the end of June, Governor Cuomo, along with Governor Murphy in New Jersey and Governor Lamont in Connecticut, rates were looking good here and not so good elsewhere. And they came out with this joint travel advisory, basically saying that any state with a sufficiently high rate of COVID-19 infections would be put on this list, and people entering any of the 3 states would need to quarantine for 14 days. The standard is supposed to be updated day to day. It's basically 10 per 100,000 residents, or a 10% positivity rate over a 7-day average. But all 3 states have updated it every Tuesday. They actually just updated the list again like an hour ago. It's been in the mid 30s for the last couple of weeks. This week, no one got removed, and Alaska and Delaware have been on and off. And it's very interesting because, Delaware is close by, and, obviously employees aren't traveling as much, but they are, still driving, in certain positions or for leisure because, after a while people start to get a little more stir crazy. And, as Sam was saying, the travel advisory is really more of an individual requirement. There's only individual penalties thus far, but it definitely does impact the workplace. I mean, the obvious question is, okay, so an employee went on vacation, they weren't directed to, now what? Do we let them into the office? Are we not allowed to let them into the office? Do we pay them? And then, there are also some essential worker exemptions because obviously the states need critical infrastructure coming in and out. So the exemptions, they kind of differ state to state, but more or less all of them have critical infrastructure that needs to enter. New Jersey has a broader business exemption, which kind of suggests if you're in the state to work, you don't need to quarantine. Healthcare providers, pretty much the standard essential worker. New York's are a little more detailed in terms of how long you're in the state, what exactly you need to do. But that's really kind of the overview of the travel advisory. Again, it's really more of an individual thing. Enforcement's definitely been different amongst the three states. When this started out, New York right away basically said this is a requirement, not an advisory. Connecticut and New Jersey were more like compliance is really encouraged, but we don't have a way of enforcing it. New York had been enforcing it by having, greetings at the airport, like Sam was saying, and that has been happening on domestic flights, um, and also just contact tracing, and carry some pretty heavy fines. Connecticut actually joined suit as well, and they now have a form and are fining people as well, not quite as much as New York. And New Jersey is still asking for voluntary compliance. But one big step taken by New York off the bat, and this will transition my discussion, is that Governor Cuomo signed an executive order basically saying if you're quarantined because you voluntarily traveled to a state that was designated as a high rate of COVID, you are not eligible for paid leave benefits under the New York COVID-19 emergency leave law. And that was a pretty big, I guess, connection between these two mandates. So with that, we can transition into the discussion on paid leave and COVID. I guess before getting into the federal and state law, just to give an overview of the landscape, when COVID kind of kicked off, no one really knew what to expect. There were a couple of early mandates providing for paid leave related to COVID specifically. New York was one of those. The federal law was one of those. And then we saw states like New Jersey with an existing paid sick leave law that kind of just kept everything the same, but amended the reasons for use to account for circumstances like a declaration of emergency by the governor related to a pandemic. So we've seen a number of different ways in which sick leave obligations are impacted across the country, whether it's an existing paid sick leave law that was amended, an existing paid sick leave law that there's non-binding guidance on, applying it to COVID-19, an entirely separate COVID-19 mandate. We've even seen some stay-at-home orders saying that all employer-provided documentation practices are suspended, whether you're providing benefits pursuant to your own policy or because you're complying with the law. So we've really seen the landscape just completely change overnight. Obviously, the biggest development was the Federal Families First Coronavirus Response Act. That went into effect on April 1st. It sunsets on December 31st, 2020. So only in effect for this year, but pretty monumental legislation nonetheless. In terms of the private employment sector, it applies to employers with fewer than 500 employees nationwide. So, a good amount of businesses are covered. Not everyone, but a lot of states and localities have gone and said, okay, if you're in our jurisdiction and have over 500 employees nationwide, we're basically imposing the same law. We won't be discussing those today, but a lot of people are covered by the FFCRA or some related mandate. The FFCRA provides two types of paid leave. It provides emergency paid sick leave and paid family and medical leave. They're similar but distinct benefits, at least under this law. The paid sick time benefit, basically an employee's eligible provided they're working for the employer when they're hired during this time. And it is a 10-day paid leave benefit, with full-time employees being able to take up to 80 hours and part-time employees being able to take an amount of hours based on what they work over 2 weeks. There's a number of different calculations based on whether the employee works a normal schedule, a variable schedule, has worked more or less than 6 months. But the takeaway is that it's a average amount of hours based on what they work over 2 weeks. The amount of paid family and medical leave someone may be entitled to is up to 12 weeks. But the big catch here is that the paid family and medical leave benefit is a amendment to the Family and Medical Leave Act. As you know, the Family and Medical Leave Act provides 12 weeks of unpaid leave over a 12-month period for certain reasons. And the FFCRA basically adds this paid family and medical leave circumstance where, to the extent an employee hasn't used their FMLA entitlement, they may be able to take the leave for a specific covered reason and be paid. So I'll get into the covered reasons now. So paid sick time is definitely a broader benefit. There are 6 reasons listed that an employee can take paid sick time, but really 5 in practice. They are on the screen, but just to go through them quickly, an employee can't work or telework, and they're subject to a federal, state, or local quarantine or isolation order related to COVID. The employee's been advised by a healthcare provider to quarantine because of COVID concerns. They're experiencing symptoms and seeking a medical diagnosis. They're caring for an individual who's subject to either a state, local, or federal order or a health provider's recommendation. And interestingly on this one, it is an individual, not necessarily a family member. When I was first looking at this law, I kind of just like, oh, family member, but it's not the case. It's a little broader. And then the 5th reason is an employee caring for a child because their school or child care provider, place of care is closed because of COVID-related reasons. The 6th reason is a catch-all. We haven't seen it applied yet. Basically, whatever the Secretary of Health decides with the Secretary of Treasury, and they've never announced any similar circumstance. And we're into mid-August, so you never know what's going to happen, but as of now, that reason kind of remains irrelevant. Paid family leave can be taken for also because an employee is caring for a child whose school or place of care has closed for COVID-19 public health emergency reasons. So it's basically just grabbing one of the paid sick leave reasons and providing another benefit. So I guess before going into the rate of pay, it probably makes sense to talk about the paid family medical leave benefit and how it interacts with the paid sick leave benefit, if it does at all. And basically, the only way that can come up is if an employee needs FFCRA leave because they're taking it because their kid's school or childcare provider is closed. So assuming they have the full 12 weeks, the first 2 weeks of this leave can either be unpaid or paid because the employee also has their up to 10 days of paid sick leave. If they have that 10-day allowance of paid sick leave, it'll run concurrently with the 12-week family medical leave allowance, and they'll get pay in the first 2 weeks. If they had to use it for another reason, say they had symptoms earlier in the year, the first 2 weeks could be unpaid. In the later 10 weeks, the family medical leave pay kicks in. When an employee's out taking family medical leave, they get paid at 2/3 their regular rate, but the pay is capped at $200 a day and $10,000 in the aggregate, given the 10 weeks of pay that they're entitled to. Now, shifting back to paid sick time and the rate of pay there, that's going to depend on what reason the sick time is being used for. If the employee is using it to kind of care for themselves or do something for themselves, reasons 1 to 3, they were subject to an order, they were recommended to quarantine or they have symptoms, they're going to get their regular rate of pay. It could be capped at $511 a day and 110 in the aggregate. If the employee is taking the leave to care for someone else, basically care for an individual who's subject to an order or for a kid whose school's closed, then they're going to get it at 2/3 pay, capped at 200 a day and 2,000 in the aggregate. So what we're seeing there is basically a distinction between whether the employee is taking it for themselves or someone else. And the final thing to keep in mind is that these benefits are required in addition to other paid leave benefits. These are paid leave benefits either provided by an employer, so paid time off, vacation, or required by law, say a given state or local paid sick leave law. And basically, it just says you can't require someone to use their other paid leave benefits for a covered reason before they use the FFCRA leave. And you can't require them to use unpaid leave, so say their FMLA, because it also gives paid family leave benefits. And as discussed earlier, the paid family medical leave benefit does have some relation with FMLA. If you use FMLA for other reasons, you may not have as much of the paid family leave benefit. So before I go into the New York COVID law, I guess it's a good time to stop and just see if anyone has any questions on the FFCRA. All right. So the state law is very different than the federal law. It went into effect a little earlier, but unlike the federal law, it does not have an end date. The federal law sunsets at the end of the year. This law could be around for as long as the pandemic. Maybe they adapt it to deal with future public health emergencies, but as of now, it's sticking around. Here, the amount of leave that an employee gets and the type of leave the employee gets depends on the size of their employer. We summarize this in the context of private employers, but basically a small employer, an employer with 10 or less employees, a net income of $1 million or less, they are not obligated to provide paid sick time. They are obligated to provide unpaid sick time, but during that time, the employee can either take paid family leave or disability leave, depending on why they're absent. Employers with 11 to 99 employees or 10 or less employees, but with a net income of greater than $1 million, they're obligated to provide 5 days of paid sick leave. And thereafter, for the remainder of an employee's quarantine or isolation, or their child's quarantine or isolation, they are obligated to provide emergency paid family leave or disability benefits. And employers with 100 or more employees are only required to provide 14 days of paid sick leave. Importantly, these days are calendar days. So for full-time employees, it comes out to be, 10 days, 80 hours. For part-time employees, also kind of some prorated portion, unless I guess it's normal for them to work over 40 hours, in which case it's not too clear on that. Actually, the calendar days aspect was clarified by non-binding guidance, but it appears to kind of provide a similar amount as the FFCRA does for paid sick leave. So why can someone use New York COVID-19 leave? The covered reasons are way smaller than under the federal law. Basically, to use emergency paid sick leave or disability benefits, depending on what an employee is entitled to, the employee needs to be subject to a mandatory or precautionary order of quarantine or isolation issued by the New York State Department of Health, a local board of health, or any other government entity who can issue a quarantine or isolation order. Emergency paid family leave, kind of the same deal, except the child would be subject to the order instead of the employee. There are a couple of disqualifications. The first is where an employee is asymptomatic and physically able to telecommute or work remotely. The other is international and domestic travel. Basically, as Sam was discussing earlier, travel to a level. I think the law here says 2, 3, or 4, but I know Sam mentioned level 3 is where pretty much everything is. If the employee does it, it's not at the employer's direction, they're on notice of the advisory, they are ineligible for the benefit. And basically, the executive order passed by Governor Cuomo extended that requirement to the domestic travel advisory. So, where an employee travels, not at the employer's direction, they know of the advisory, they are not eligible to receive any COVID leave benefits under the state law. Importantly, when the law was originally drafted and only addressed the international ban, there were provisions that basically said while they're not entitled to COVID leave provided by this law, the employer needs to offer them any existing paid leave benefits that they'd be entitled to. And if there's no existing paid leave benefits, maybe they exhausted them all, they need to give them unpaid leave. So obviously, with an eye towards public health there, the law is basically saying if someone's a risk to spread this virus in the workplace, they don't come in. Whether it's their existing paid leave, unpaid leave, not this COVID leave, but they don't come in and they'll get something. The rate of pay required when paid sick leave is taken under the law is basically what the worker would have otherwise been paid if they were working the hours instead of taking leave. That is from non-binding guidance. The law was silent on this point, but it basically suggests that this rate is higher than the FFCRA, where there's rate differentials and where the pay could be capped. Here, you're basically, if you're salaried, your pay is getting continued. If you're hourly, you're getting paid as if you punched in and punched out on time. For emergency paid family leave and disability benefits, like general paid family and disability benefits, it's a state insurance fund type benefit. It replaces a portion of employees' wages. The amount of wage replacement is based on a maximum that's equal to the average weekly wage of employees in the state. And then on existing paid leave, like the federal law, the New York law also requires that emergency paid sick time is separate from and without loss of an employee's existing paid leave accruals. Now, if you think in the context of New York, right now we have a lot of employers in New York City, so they're obligated to provide earned safe and sick time under the New York City Earned Safe and Sick Time Act. If they're in Westchester County, there's both a sick time and a safe time mandate there. And New York State has a non-COVID specific paid sick leave law going into effect on September 30th, and employees will be eligible to use paid sick leave come January 2021. And as noted earlier, this law doesn't have an end date. So definitely, putting this leave when an employee needs it for COVID reasons ahead of a number of other leaves that may be available. And this also includes any employer-provided PTO, vacation, and whatnot. One other interesting provision in the New York law is that basically it says all of the leave provided, paid family, sick, disability, would become unavailable to the extent that the federal government, through a law or a regulation, provides sick leave or other employee benefits, so basically accounting for family leave, disability, sick leave, related to COVID-19 with the caveat that if the New York law would provide more generous benefits in excess of what's provided by the federal law, employees would basically be entitled to the excess benefit provided by the New York law. And if there's one thing clear from this discussion, it's that these two laws do not mesh very well. They, in rare instances, depending on employer size, may provide the same amount of paid sick time, but otherwise there's different benefits at play. There's a higher rate of pay under the state law than under the federal law. There's more reasons for use of sick leave under the federal law than under the state law. So they really don't mesh well. So while that provision is there, a more conservative reading of it basically says that the FFCRA does not affect New York paid leave obligations. And then you also want to keep in mind that the FFCRA says that leave can come before any other paid leave benefits provided to employees. So if you're obligated under both, basically the FFCRA says this leave takes precedent and this is what goes first. So really some interplay standards that don't mesh well there, and it can get confusing to administer. So that's all on the overview of these laws. I have a couple of scenarios that I'm happy to walk through, but if anyone has any questions, happy to take those first.
Ryan, we actually had a question come in.
Yes, Ryan, I sent you 2 questions to answer.
I told you guys I wasn't going to be good with this computer, the whole use thing. Let's see. All right. So I see one from Greg to everyone, from Sam Rubenstein to everyone. So is this asked and answered? Is this all?
Yeah, Ryan, here, let me.
Oh, Kim. Okay.
Do you want me to help you out here?
Sure.
One question came in is that if an employee is positive for COVID, would they qualify for New York COVID paid sick leave?
So basically, the short answer is yes. The employee has to be subject to a mandatory or precautionary quarantine or isolation order. If they have tested positive for COVID, the health department will issue that order. I hope. There are a couple of things. Well, there's a couple of things at play. One, I assume that the employer is obligated to provide paid sick time. If it's a small employer, they may be entitled to disability benefits and unpaid sick leave. If they're a middle-sized employer, they may be entitled to 5 days of paid sick leave and then disability benefits for the remainder of the quarantine. So, depending on the employer size, if the employer is obligated to provide sick time benefits, yes, that employee would be entitled. It's an interesting question, actually, because of that narrow reason for use. There is guidance on the state's website. It's specific to paid family leave, but in working with it, the team has decided it's equally instructive for paid sick leave purposes, where basically employees are instructed to contact their local health department to get an order, if they'd qualify. And sometimes, for one reason or another, they can't get there. The health department, especially in the beginning of this pandemic, was very overwhelmed. So the guidance basically provided, and I will pull this up really quickly. So the guidance basically provides that, eventually you're going to need to get that order. But in the interim, if you can't get the order, you can go to a healthcare provider, and the healthcare provider can provide an attestation that you are entitled to either an order for mandatory isolation, mandatory quarantine, or precautionary quarantine. And that guidance basically lists out what the healthcare provider needs to attest to for you to be entitled to that order. And of course, the first thing, mandatory isolation. It says if you are subject to mandatory isolation, the attestation must say you have tested positive for COVID-19 or testing is currently not available, but you have symptoms and had contact with a known COVID case. So basically, the short answer of that is when an employee tests positive for COVID-19, they should try and get an order. If they can't get an order, they should go see a healthcare provider who attests they have COVID-19. When the healthcare provider does that, the healthcare provider's attesting to say they are entitled to this order, and then the employee should get it as soon as they can and give it. But yes, that would be a mandatory isolation.
Great. Thanks, Ryan. One other question that I think is just helpful for everyone to hear the answer to, and that was on the employee threshold. These laws list thresholds. Under the New York COVID law, when we're talking about the threshold number, is that limited to New York State, like employees actually in New York State, or is that employees everywhere in the US?
That's a very good question, Kim. I have the same question. They have not made that clear. We tend to assume nationwide,
Right.
because there's no less. I mean, my gut just wants to tell me it's like it's such a state-specific benefit. Like, I want it to be the state, but there is nothing there. So, we do assume nationwide for now. We think it's the safest approach, one, because you're getting more employees that way. But if you think about it, the larger you are as an employer, basically the more that's coming out of your pocket. If you're an employer with 100 or more employees, you are providing 14 calendar days, however much an employee works in that time, of paid leave at their regular rate. If you're smaller, some or all of the employees' paid leave is coming from a state insurance fund. So obviously there are business considerations and risk considerations to take into account, but from a strict legal standpoint, the safest approach would be to assume nationwide, because that way you're giving the most generous benefit and counting the most employees.
That's very helpful. And I think we've seen that trend with lots of other policies too, where we're looking now at nationwide counts versus just individual state counts.
Mm-hmm.
So I think it would be great to run through some of the hypos. I think that'll also clear things up for people.
All right. So the first one, and I don't know if you want me to ask it and then someone wants to provide an answer, or if I should just give the answer. How do you want to do this, Kim?
I think why don't you read the hypo and then you should give the answer.
Okay.
But people have questions.
And by the way, it's funny, your last question, I basically put my I basically said all of the company's employees are in New York just to avoid that issue. But basically, so the first one is an employee's child's school is closed by order of a public official due to COVID-19 public health emergency. The employee works for an employer with between 11 and 99 employees in New York. Which leave benefits would the employee be provided? So here, the employee would be entitled. Oh, do you want me to take a pause or?
That's okay. Go ahead.
Here, the employee would be entitled to emergency paid family leave benefits under the FFCRA. And depending on whether or not the employee had used their FFCRA paid sick time entitlement, they may be using those benefits too. The covered reason is a child's school or daycare provider being closed for concerns related to COVID-19, and the paid family leave benefits up to 12 weeks. The first 2 weeks are as either unpaid, or the paid sick time for the same reason runs concurrently. The big catch here is that although the employee is entitled to paid family leave under the New York COVID emergency leave law, the employee's child is not subject to a mandatory or precautionary order of quarantine or isolation. We kind of got into that in addressing the first question earlier. The law itself isn't so clear. if a school's ordered closed, is that a mandatory precautionary order of quarantine or isolation or not? The guidance basically suggests that it's not. What I was reading off earlier, the employee tested positive for COVID-19, the employee had symptoms, the employee had close contact, and the same would be for the child, basically suggests that the order needs to be individualized to an employee or an employee's child. So that's the big catch there, where even though this employee could be entitled to state law paid family leave benefits, this was just a school-wide closure. That is why the FFCRA and not the state law would apply here.
Great. I think that the second hypo would be great to cover too quickly. I know we're running over time, but we're going to finish up in just a moment. But I know that the question came in, which I answered individually, but it relates to the second hypo. So I think it would be great to cover this.
All right. So here we have an employee working for an employer with 200 employees in New York. So a large employer, and the employee plans, and I should have said goes on a vacation to Florida, which is a state designated with a high COVID-19 infection rate. That was before the employee went, after the employee came back. And upon return, in compliance with the travel advisory, the employee self-quarantines. The employee is not in a position where working remotely is possible. And the question is, which benefits are the employee entitled to? Are they entitled to any benefits? So, as discussed earlier, Governor Cuomo signed an executive order basically saying you are not eligible for COVID-19 paid leave benefits if you voluntarily traveled, you knew about it, and you come back. The FFCRA is different on this point. The first covered reason for use is when an employee is subject to a federal, state, or local quarantine or isolation order. And basically what the state's travel advisory, and I say that in quotes because it's really a requirement, the state's quarantine order is it's a state-imposed quarantine order. The U.S. Department of Labor's rules expand on this covered reason for use with federal, state, or local quarantine or isolation orders. And it's pretty on point in answering this. It says a quarantine or isolation order includes quarantine, isolation, containment, shelter in place, stay at home orders issued by any federal, state, or local authority that causes an employee to be not able to work. This also includes when a federal, state, or local government has advised categories of citizens. So unlike the state law, which it's employee specific, categories of citizens, for example, certain age range, certain medical conditions, here, travelers, to shelter in place, stay at home, isolate, or quarantine. So here, while you're not entitled to state law benefits, you are entitled to federal law benefits. Again, so it's basically a twofold thing there. It's the exemption based on Governor Cuomo's order. And before he even signed that order, we were getting some questions like, would this be a covered reason for use of the leave? And what we teased out is, well, on the one hand, it is mandatory, but on the other, it's not specific to the employee. So because it's not specific to the employee and because the employee would otherwise be exempt, it's the FFCRA that controls here. And the last question is basically the same facts. So if you want me to just wrap it up with that one, it's basically the same exact fact pattern, but we assume that the employee has exhausted their FFCRA paid sick leave. And the question is, can the employee take any leave? So mentioned this earlier, but the domestic travel exclusion from sick leave under the COVID law was built off of the international travel. And the international travel required that if you're going to deny an employee COVID leave, good, you should, but you have to offer them their paid leave accruals. So here, an employee exhausted their FSCRA leave, but they may have New York City paid sick time, Westchester paid sick time, vacation time, paid time off, whatever benefits a company provides. And if that is the case, they need to be offered those benefits. If they don't have those benefits, then they should be offered an unpaid job protected.
Great, thanks. Well, I know we ran a little bit over time, so I wanted to thank everyone for joining us today. And if you have any questions that you come up with, afterwards, feel free to reach out to either Sam, Ryan, or myself, and we're happy to answer any questions you have relating to these topics covered today. And thank you again for joining us.